Lindsay Clancy breaks down in the courtroom as both sides go head-to-head with heated arguments.
What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury.
It is not the Commonwealth putting on a circus or a parade. It's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children and the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
We're unpacking all the arguments from both sides in week 1 of the Lindsay Clancy trial. This is Scandal, presented by Law&Crime. I'm Gillespie. Fireworks in the courtroom and opening statements haven't even been presented yet. That's how tense things are in Plymouth County, Massachusetts, where 35-year-old Lindsay Clancy is accused of murdering her 3 young children, strangling them with exercise bands in her upscale South Shore home. But here's the thing, Lindsay's defense doesn't deny it. In fact, they admit she killed her children, but they say she was experiencing postpartum psychosis at the time, and that voices in her head and a cocktail of nearly a dozen medications caused her to act. And we'll get to the specifics in a moment, but first, the fireworks that erupted in the Plymouth County Courthouse this week when a motions hearing took a turn.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now, all right?
So he gets an opportunity to say it.
No, I stopped that.
But that wasn't the only moment that got tense. The Commonwealth had a chance to fire back, and boy, did they ever.
The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children and the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that. All right?
During all of this tension, Lindsay Clancy herself was so overcome with emotions during these arguments, she began crying. I was there in the courtroom all week, and I kept a close eye on Lindsay Clancy during all of the proceedings. And let me tell you, it's very stark when the bailiff asks the entire courtroom to stand, and everyone does except for Lindsay, who is confined to a wheelchair. I mean, it's not lost on anyone that she has physical impairments because there are nurses behind her at all times. As far as Lindsay's emotions go, I saw kind of a range. Most of the time she was stone-faced, listening in to what everyone was saying, seemingly following along with everyone, but showing very little emotion. A few times, though, I did see her do quote-unquote ordinary things like pop a mint, laugh with her defense attorney, but those moments were few and far between. Most of the time, she had a blank stare and just a completely straight face. When the judge read the allegations against Lindsay that she'd strangled her 3 children, I was seated behind Lindsay's parents and her grandmother, and as these allegations were read out, Lindsay's mother hung her head, almost even unable to look forward. And you have to remember, these are her grandchildren that are gone. It has to be a heartbreaking thing to hear over and over again as the trial moves forward. So, needless to say, this week's proceedings saw everything. Lindsay Clancy breaking down, tensions running high in the court, and we're going to take a closer look at all of that. But first, let's backtrack just a bit to discuss how we got here. Now, I've been reporting on this case since it broke 3.5 years ago, and since then, a major question has emerged. Did Lindsay Clancy murder her 3 young children in cold blood, or was she suffering from postpartum psychosis and had a true mental break? Now, the Commonwealth alleges the former, that Lindsay Clancy acted knowingly and with premeditation, murdering her 3 young children. That's 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan, strangling them with exercise bands on January 24th, 2023. But since the incident, Lindsay's defense and her former husband, Patrick, have been steadfast that Lindsay was suffering from a mental break at the time. They don't deny that she killed the children, but they do deny that it was murder. Now, at this point, Patrick and Lindsay Clancy are divorced. Patrick is actually remarried, but back in 2023, the couple were together, having been married since 2016. And in the early years, Lindsay worked as a nurse at the renowned Mass Gen Hospital in Boston, and by all accounts, she was very loving and dedicated to her patients. According to multiple reports, Lindsay's demeanor only changed after having kids. She reportedly started to develop anxiety and depression, especially after her second and third children. After the birth of the third baby, Callan, Lindsay's defense says her symptoms reached an all-time high. They say she was diagnosed with bipolar disorder and even admitted to a psychiatric hospital just north of Boston for her struggles with thoughts of self-harm. Her stay there happened in the weeks before the murders, but her mental health treatment started way before that. According to court docs, Lindsay had been on a regimen of up to 13 different psychotropic meds, both to monitor her mood and her sleep. That's medications like Prozac, Zoloft, and Ambien. A lawsuit filed by Patrick Clancy would later refer to all of these prescriptions as a cocktail that created the perfect storm of terror. Just this year, Patrick filed a lawsuit against the doctors, claiming this large amount of drugs actually hurt Lindsay more than it helped her, and in fact, altered her mental state. Patrick had been so worried about Lindsay in this time after her concerning journal entries and all of this, he hardly ever left her alone. Either he would stay with her and the kids, or a family member would come and do the same. But that's not what happened on the day of January 24th, 2023. That morning, Lindsay Clancy's oldest daughter, Cora, was having some stomach issues, so Lindsay took her to the doctor for an appointment. When they got back, Lindsay and the kids played outside in the snow. They even built a snowman. Around 4 p.m., Lindsay Googled the 3V restaurant in Plymouth and looked up the driving distance from her home in Duxbury to the restaurant. And this is important, as prosecutors will later argue Lindsay murdered the children with premeditation, making sure that Patrick would be out of the house long enough that she could complete this act without interruption. But according to a lawsuit filed by Lindsay's team, that's not exactly what happened. Yes, she did send Patrick out to get dinner, and yes, she did ask him to run to CVS to pick up something for Cora. But after that, they say she suffered a severe mental break. This is straight from that lawsuit. It reads, as soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. This is your last chance. Kill the children so you can kill yourself. Lindsay's team argues she felt a force come over her and started to experience a series of hallucinations. She says she experienced a dreamlike state where she had no choice but to follow the orders of these voices, and then described watching herself carry out the murders. Back to the lawsuit, Lindsay described, I lost all control. My body started acting without any control on my part. I was just following commands. All action. The voice demanded action. Lindsay proceeded to strangle each of her children, uttering, "Go to God, baby." Prosecutors say Lindsay used exercise bands to strangle each of her children before ingesting a substantial amount of medications, cutting her wrists and neck, and jumping out of a second-story window to land on the frozen ground. She suffered severe injuries from the jump and remains permanently paralyzed from the waist down. Since the children's death, Lindsay has been in custody and actually in medical care. She's even appeared in past hearings from a hospital bed, and this week she was accompanied by 2 nurses every single day. And that leads us to this week, the start of the trial against Lindsay Clancy. She faces 3 charges of murder brought by the Commonwealth for the deaths of Cora, Dawson, and Callan. The defense has long opposed these charges, but is now ready to fight using the lack of criminal responsibility defense. Now, this is most commonly known as the insanity defense, meaning the defendant says they're not guilty by reason of insanity. But that's not exactly how it works here in the Commonwealth of Massachusetts. This is straight from the Commonwealth statute. It reads, if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. So that means 0 burden on the defense to prove that Lindsay Clancy had a mental disease or defect. In fact, it's all on the burden of the Commonwealth to prove that despite any sort of diagnosis, that Lindsay Clancy was criminally responsible at the time of the murders. The statute goes on to specify, to establish that the defendant had the substantial capacity to conform their conduct to the law's requirements, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the alleged offense did not deprive the defendant of their ability to behave as the law requires, that is, to obey the law. Now, I was in the courtroom this week for jury selection, and let me tell you, this was confusing to potential jurors. I heard during individual voir dire at least one person, a prospective juror, couldn't understand what all of this meant. He said, quote, "I don't understand the difference between not guilty and not guilty of insanity. I just don't get it." This man was ultimately excused and he's not seated on the jury, but this is a very important thing for potential jurors to understand, so much so that it was actually on the jury questionnaire. Now, I got my hands on it from a source at the Boston Globe. There were 8 questions total, and one of them was the following. The defense in this case is that Ms. Clancy is not guilty due to not being criminally responsible at the time that she killed her 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? Additionally, the questionnaire asked a lot about mental health for obvious reasons. A few of these questions included, have you, a family member, or close friend ever been diagnosed with postpartum depression, generalized anxiety disorder, or bipolar disorder? Another question asked, have you, a family member or close friend, had an experience with a psychiatrist, psychologist, or mental health facility that would make it difficult for you to be fair and impartial in this case? And let me just say, there has been 0 testimony yet. This entire week, it was simply jury selection and a few motions hearings. And yet, I saw multiple people crying, 3 yesterday alone. And here's what's staggering. As potential jurors were called to individual voir dire, they were just inches from Lindsay Clancy herself. I heard multiple prospective jurors saying things like, quote, "I'm a mom and I just can't." I saw people bringing literal boxes of tissues to voir dire crying in front of Lindsay Clancy herself, something I've never seen before in jury selection. Now, on day 2 of all of this, there was some additional drama when a previously seated juror came forward in front of both the judge and the Commonwealth and the defense. And let me tell you, he was emotional. He was loud. I even could hear him over the white noise. And this is what he said. It's a direct quote. "I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible. I don't think I can handle it." And mind you, all of this is said just inches from Lindsay Clancy herself. Now, that juror was ultimately removed from the jury, as were 2 others who had previously been seated. There was really so much confusion this week during jury selection. Both sides agreed they wanted to seat a panel of 18 jurors, so 12 jurors plus 6 alternates. And every time it seemed like they were close to seating 18, a juror who had already been seated would be removed. But finally, Thursday afternoon, the entire jury was seated. As it stands, it's made up of 12 women and 6 men. And I think it just goes to show how contentious this case is. People have strong feelings on both sides, and it's of the utmost importance that an impartial jury is seated to decide Lindsay Clancy's fate. But emotions are running high, and we saw proof of that yesterday in court. Now, we weren't allowed to record jury selection, but during motions hearings, it was fair game. So thankfully, we have all this on video. Now, the first discussion was regarding a motion that Patrick Clancy himself filed on July 20th. In this motion, Patrick Clancy requests that multiple pieces of evidence be impounded, meaning they could not be released to the media or the public. The motion reads in part, "The potential harmful and everlasting emotional impact to Mr. Clancy and his family of any public dissemination of such graphic and sensational evidence and exhibits related to his 3 children is immeasurable." The items that Patrick is hoping to keep away from the media are the following. The 911 call that Patrick made when he found Lindsay Clancy and the 3 children, photos of the children, including autopsy photos and photos of them before their deaths, the clothing that the children were wearing at the time of their deaths, and, quote, material Patrick gave to both sides. Now, Patrick was not in court yesterday for this argument, but his attorney, David Meyer, was.
On behalf of Patrick Clancy, the father of the 3 child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case. how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury. And he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And I respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the three victims in this case, Mr. Clancy respectfully has an opportunity and a right to be heard through me or through his counsel.
Judge William F. Sullivan then asked both sides for their input, starting with the Commonwealth.
With regard to the 911 call, Your Honor, I believe it's a public record available at a public records request, but I would defer to the court in terms of how you want to restrict publication of the 911 call during the trial or thereafter, as long as the Commonwealth is still allowed to show or play, rather, the recording for the jury as the court has previously allowed that motion. Regarding photographs of the children, we had already addressed the autopsy photographs. The Commonwealth was going to request impoundment of those, and we would agree that they should not be broadcast or photographed in any way. Crime scene photographs, the children had already been removed from the home when the crime scene photographs and video were taken, so they will not appear in those photographs. The only blood in those photographs would be the purported blood of the defendant in the bedroom and on the exterior of the home, and then a small amount of blood from Cora in the basement.
And here's where the fireworks first began. When it came time for the defense to take on this motion, attorney Kevin Reddington did not hold back.
I have been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having Patrick Clancy, who's a young man who has suffered one of the worst tragedies that anyone could ever suffer. How that guy is still not an emotional basket case is beyond me, and he has been. But nevertheless, he is trying hard to move on with his life. He has, as the court is aware, they're divorced. He's remarried. He has a family. He has his extended family. Your Honor heard statements, and I know for a fact that it's true, that his family, totally innocent people that have nothing whatsoever to do with this case, are being harassed daily by news media, the New York Post, and all the rest of these types of salacious news media outside their door. This is his family. Some of them are in California. They have nothing to do with this case. But nevertheless, they are being hounded by the media. And the district attorney wants to put that guy on the witness stand and show little onesies with bodily fluid of his child, and they want to have him stand there, or they're going to let him stand in the hallway while we listen to the 911 call.
Mr. Reddington, that's another issue. That's another motion. The question we have right now, respectfully, is Mr. Meyer's request as to how we should deal with this in regards to the media.
I agree with Mr. Meyer's request, as I told you with the sidebar. I think it's very appropriate. I think he argued it effectively.
And just when you thought the judge would shut it all down, both sides were back at it and things got tense.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now, all right?
So he gets an opportunity to say it.
No, I stopped that. And if you want to address that in a different way, then we've got another motion in about 5 minutes that we're going to probably be talking about that. So let's talk about that then. This is I let counsel go and think it was going to wrap back up, and I didn't see that it was going to wrap back up in regards to the request. So that's why I stopped it, all right? This is not accomplishing anything in regards to the question of access to these 4 pieces of evidence.
All of this was the precursor for Reddington's motion, asking the Commonwealth to limit the number of first responder witnesses they plan to call.
This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement.
We stopped the soundbite there, but Reddington goes on to list 17 different first responders from various agencies, all on the Commonwealth's witness list.
So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here, and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves, and it may have worked in the grand jury, but it shouldn't work in a jury trial.
When it's time for the Commonwealth to respond, things get tense all over again.
Here, unfortunately, we have 3 victims, so that multiplies those witnesses by 3. We also have the defendant herself, who was treated at the scene, so then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what? I'll tell you, we don't need that. All right? We don't need that.
Lindsay Clancy herself was so overcome with emotions during these arguments, by the way, that she began crying. The judge made note of this motion, but ultimately decided it was too early to rule on anything definitively.
I guess probably just so you'd be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate parties read. This is exactly why we have motions in limine, so I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action on that.
Court is dark on Friday, but opening statements are expected for Monday. And I've been told by Kevin Reddington himself that the first witness is expected to be Patrick Clancy. He'll be called by the Commonwealth as their star witness, but also will be questioned by the defense under special circumstances, meaning it will be more than just cross-exam, but the ability for the defense to put on their case a little bit early. It's not something that I've seen before, and I'm both eager to see what happens, but also trying to emotionally prepare, because the testimony and the evidence that are going to be presented in this 6 to 8 week trial is going to be heart-wrenching. And at the end of the day, we can't forget the lives lost of Cora, Dawson, and Callan Clancy. Their lives were cut far too short. No matter how this all shakes out, it's going to be a monumental case, and we'll be there to cover it all. Law&Crime will be live streaming the entire trial, gavel to gavel, and I'll be here to give you recaps as the most shocking courtroom moments unfold. And that is where today's episode of Scandal leaves us for now. If you like what you saw and you want to see more or connect with me on social media, you can find me on places like Instagram at Sierra Gillespie. Thanks for watching today's episode of Scandal. As always, I'm your host, Sierra Gillespie, and I'll see you next time.